A police officer is walking toward you on the street. Your heartbeat becomes irregular. A strange excitement. You don't know whether you have to stop. You don't know whether you have to speak. You don't know whether you have the right to walk away. Most people get this completely wrong. Imagine this. You are walking home, an ordinary Tuesday, a day when you have no special plans. Then, a police officer stops you and says, "Hey, can I ask you a few questions?" What do you do? Most people immediately think, absolutely, I have to cooperate, I have to answer, I have to be polite and obey unconditionally whatever they want. This instinct feels like the right choice. You want to stay in the safe zone, but legally, that is not always correct. Here is what most people do not realize. Every police interaction is not the same. The law actually divides police encounters into completely different categories, and your rights depend entirely on which one you are in. The first type is called a voluntary encounter. An officer comes up to you, starts talking to you, asks questions. Here is the thing. In a voluntary encounter, you are legally free to walk away. Whether you are black or white does not matter here. The laws are clear. The officer does not have the authority to force you to stay, does not have the authority to force you to answer. The Supreme Court made this clear in 1991. As long as a reasonable person would feel that they could comfortably walk away, you are not in custody. You are in an ordinary, normal conversation. But this is exactly where things get complicated. Most people do not know when a voluntary encounter ends. The officer's tone of voice changes, maybe they step closer, maybe they say, "I need you to stay here for a minute." Suddenly, you are no longer in a conversation, you are in what is called a detention, and now the rules change completely. So, when can a police officer force you to stop? The Supreme Court answered this question in 1968. The case was Terry versus Ohio. And this case established a legal standard that still governs every street stop in America today. The rule is this: an officer needs reasonable suspicion, not evidence, not a warrant, not a crime they have already witnessed, just reasonable suspicion. This means specific, articulable facts, things the officer can point to and explain that involve threat or crime, not a hunch, not the neighborhood you are walking through, not your skin color alone, something specific. If this standard is met, the officer can detain you briefly, can ask questions, can even pat down the outside of your clothing if they believe you might be armed. This pat down is not a full search. It is just a limited check for weapons, nothing else. Now, everyone's question: do you have to answer? Generally, no. The Fifth Amendment gives you the right to remain silent. But, and here is the part almost no one knows, this right does not automatically kick in. The Supreme Court ruled in 2010 that simply staying silent is not enough. You actually have to say it out loud. Something like, "I am invoking my right to remain silent." If you just stay silent and do not say those words, your silence can be used against you in court. The Supreme Court applied this in the 2013 case Salinas versus Texas. There is one more thing that varies by state. In roughly half of the US states, you may be legally required to state your name during a lawful detention, not your full identity, not your address, not your life story, just your name to the officer. But in other states, including California, there is no such requirement at all. Always check the laws where you live. This is exactly where people make their most costly mistakes. Almost everyone starts telling their entire story. They explain themselves. They volunteer information. They try to appear cooperative, thinking it will protect them from aggressive police behavior. They think more words mean fewer problems. But the painful truth is this: everything you say during a police stop can be used against you in court. This is not a television show. This is real law, upheld by the Supreme Court. The biggest myth on the internet is just be honest, everything will work out. Honesty is a virtue, but legal conversations are not places for improvisation. You can be calm, you can be respectful, you absolutely should be, but being calm and staying silent are not opposites. Another myth: running from the police means they can't stop you. Wrong. The Supreme Court ruled in Illinois versus Wardlow that unprovoked flight can become the basis for an officer to detain you. Running does not protect you from the police. It can make things worse. Now imagine yourself back in that first scenario. The officer is walking toward you. This time, you know what to ask. Am I free to go? If the answer is yes, you can calmly walk away. If the answer is no, you are being detained. Now you know your rights. You can say, I am invoking my right to remain silent. I want a lawyer. 7 words. And after that, you can stop speaking. Not out of guilt, not out of defiance, because the law gives you this right. And exercising a legal right is not a crime. The officer's job is to investigate. Your job is to protect yourself within the law. These two things can coexist. Understanding the difference between a conversation and a detention, between silence and a legal invocation, between a pat-down and a search. This understanding is what separates people who walk away okay from people who do not understand what happened until it is too late. Rights do not protect you just because they exist in a courtroom. They have to exist in your mind as knowledge. In that moment, in those first few seconds when your heart is pounding and someone in uniform is walking toward you, I would be very happy if you support me by subscribing to Rights Illustrated. See you in a new video.